Breaking news. Appeal Court discharge and acquaint Nnamdi Kanu. Hey guys, this is still DJMTV Daily News Update. The Appeal Court sitting in Abuja has discharged and acquainted the leader of the indigenous people of Biafra, IPOB, Nnamdi Kanu. The three-man panel in the detailed ruling accused Nigeria's federal government of breaching the African Union Charter on extraordinary redemption. The court declared the arrest of Nnamdi Kanu in a foreign land and subsequent transfer to Nigeria as illegal acts. The court also held that the arrest of Nnamdi Kanu, the leader of the indigenous people of Biafra, was done in clear and egregious violation of extant international law. The panel also agreed that there is no justification for Nnamdi Kanu to be tried in Nigeria when he was arrested on foreign soil. The Appeal Court further berated Justice Binta Yoko from hearing the matter, saying that the lower court lacks the jurisdiction to entertain such matters. And reacting to the release of Nnamdi Kanu, the lead counsel of Nnamdi Kanu, Chief Mike Ozokome's son, said that the acquaintance of the leader of the indigenous people of Biafra is too complex for human understanding, and it is only God who can do this. Mike Ozokome, who spoke after praying to God, thanking Jesus for getting out Nnamdi Kanu on his knees together with his team of lawyers, said Nnamdi Kanu's release by the Court of Appeal was one of those things that you can say are rare, inexplicable, indescribable, and it's only God who can fathom it, because it is depth and breadth, it is plenitude and amplitude are too wide, too complex for human understanding, he said. Let's watch the video. We'll be right back.
It is one of those things that you can say is ineffable. It is indescribable. It is only God that can fathom it, because its depth and breadth, its plenitude and amplitude are too wide, too complex for any human understanding. Nnamdi Kanu was today discharged of all the remaining 7-count charge, which 7 counts were retained by the Federal High Court in its judgment in April this year. I said it before, the court tried in striking out 8 of the 15 counts charge, but it did not go far. It shied away from striking out the remaining 7 counts. Based on that, we appealed on behalf of Nnamdi Kanu that the lower court was wrong. There was one fundamental issue on which the court today anchored its judgment, this intermediate court. And that is that the lower court never evaluated the mountain of evidence placed before it regarding the forceful capture, kidnap, torture, and extraordinary rendition of Nnamdi Kanu from Kenya back to Nigeria on the 26th of June, 2021. The lower court glossed over it. We placed this before the lower court in more than 10 paragraphs of solid materials to show the circumstances under which Nnamdi Kanu was forcibly abducted, kidnapped, blindfolded, tortured, and then rendered back to Nigeria extrajudicially, extra-legally, against the laws of Kenya, against the laws of Nigeria, against all international instruments dealing with extradition, including various sections of the Extradition Act of Nigeria, including Section 15. They violated them. They brought Nnamdi Kanu to face a 4-count charge that was still pending, contrary and against what we call the doctrine of specialty, which is that when you bring back a fugitive through extradition process, you can only try him for that offense for which you are extraditing that fugitive, not earlier counts. And you cannot continue with an earlier case against that fugitive. Now, Nnamdi Kanu was brought back to face the earlier existing counts, which were again amended first to 7 counts, and then again amended to 15 counts. And I went to court, we went to court, challenging the entire counts for being bad, for not following due process of law because the court had no jurisdiction to try Nnamdi Kanu. The lower court agreed with us, struck out 8 of the 15 counts, but retained 7. It is those 7 that we appealed against to this Court of Appeal. And today, the Court of Appeal agreed with us. And in very strong words, from Justice Adefokwe Okoje, who read the lead judgment, to the presiding justice of the Court of Appeal here, Justice Jumai Sankey, who wrote a very lengthy contributory judgment, but agreeing to the Honorable Justice Ebiowe Nikitobi, who wrote a concurring and agreeable judgment. All of them used very strong words to say that the respondent, the federal government itself, brazenly breached the laws it has itself made regarding extradition, that it never followed due process, that it never followed international conventions, that it never even followed the Anti-Terrorism Act itself. I will first meet my client, break the good news to him, then we discuss the way forward. Because the United Nations had already said Nnamdi Kanu should be paid compensation for the violation of his human rights, which this Court of Appeal again found today, that his rights were brutally violated. The Court of Appeal was emphatic about that his rights were violated. The principle of law is ubi jus, ibi remedium. Where there is a right, there must be a remedy.
Welcome back, guys. This is still DJMTV Daily News Update. So here we have it. We've heard from Mike Ozokume, who has said that it is only God who has done what he has done. The appeal court discharged and acquitted Nnamdi Kanu and said he is free to go. So guys, what are your thoughts and comments? Recall that this has been a very long journey since 2021, July 26th until date. It has been over a year. Nnamdi Kanu was kidnapped back from Kenya and also tried in the Federal High Court in Abuja under Justice Binta Yoko. And now the appeal court has discharged and acquitted Nnamdi Kanu. But the question is, will the federal government allow them go? Will the federal government allow the case to slide, or they will take it to the Supreme Court? Because the Supreme Court is the apex court, and the appeal court is just lower courts to the Supreme Court. Will the federal government take it to the Supreme Court, or will Nnamdi Kanu walk away a free man? Again, we had the lead counsel, Mike Ozokume, who has said that the appeal court said the federal government has violated Nnamdi Kanu's human rights. Therefore, when there's a violation of rights, there must be a compensation. It means that, according to Mike Ozokume, a compensation would come after this. So guys, what are your thoughts and comments? Share them with us in the comment section below.